Hey, welcome to All Things Social Security. You're about to see a question from a live viewer and my response, and it may or may not have an attached additional set of information for you, but you'll see a little invitation to that if that's the case. If what you're looking for is representation and you want us to take a look at your claim, please go to joydisability.com and look in your upper left-hand corner for the link for the free SSD evaluation. And we will take care of that for you. Thank you so much. Bye-bye. Enjoy the video.
Shiloh says, can you advise if we should upload VA disability decision letter, 100 PNT, or have them request it? Oh, I would always upload it. You know, if you can, I was gonna say weird. If you can get it to them, just do it. When in doubt, if it's nothing that's gonna hurt your case, you know, like if it says Shiloh is limited to only medium level work and, you know, can't do that heavy work anymore. And I don't think PNT will say that, but that's something that would probably hurt your case. So they're like, and this is true of all the letters, guys. So whenever you try to get like a letter from, and I know you need that for PNT for other purposes, it might help your case go faster, Shiloh. But if I always say about getting doctor's letters when the doctors don't know what path you have to weave to get to being found disabled under the rules, you know, then it's actually worse to get one because their records might have, reading between the lines, told the SSA that you were disabled under the rules, and then the doctor who doesn't know that she's really limited, she can only stand like 5 hours a day, doesn't realize that just sinks her ship because there's jobs that require less than that and all that kind of business. Sometimes it's better not to. But with PNT, obviously, that's a different story because you're using that to get on the priority track to the extent that people actually move faster on the priority track, which is questionable. Happy Sunday. Yeah, Sunday. Okay, so I was just communicating with somebody who had some questions about how to get a case or what cases can be expedited. Could his case be expedited and processed faster? Generally speaking, it's supposed to be on a first in, first out basis. I should really probably say that it's more like a first in, first worked on basis, but it's really hard to say that the first one in is going to be the first one out because processing times in the SSA can vary because each case is different. One doctor might not send his records in as fast as another doctor, and it could slow up that person's case even though they filed first. It could be scheduling a consultative exam. Maybe he had to cancel because he got sick and they had to reschedule it. So all sorts of things can make things go slower once they're processed. But generally speaking, no one's supposed to be jumping in front of anybody else for a reason other than things like that, except there are obvious reasons why sometimes it would be appropriate. So I'm going to just run down this list that the SSA shares with us. And then I will talk about one in particular, and I will try to get to other ones in different videos, maybe as they come up or as time is available. But the one that I will go into a little bit is dire need cases, and I'll explain that in a little bit because that seems to be not so uncommon. So anyway, amongst the list of things that would get priority handling by the SSA, which is where they kind of direct that they should be developed and processed expeditiously, they include compassionate allowance cases, critical cases, dire need cases, and that's the one we're going to go into a little bit, presumptive disability or blindness, administrative law judge hearing cases, appeals counsel cases, homeless cases, terminal illness cases, also known as TERI, inquiries from public officials, delayed cases, military causality, wounded warrior, permanent and total cases, and quick disability determination cases. Okay, so going back up to the dire need cases, let's just go over those. And you can get more detail on those at DI. Oops, nope, I'm sorry, that was critical cases. 20030 is for dire need. So when you go to that, they give you a little quick blurb where they say that, let's see, well, I'm just going to read it to you. In processing cases, situations may arise that will require individual consideration and judgment with regard to expediting certain hardship cases. So dire need tends to be a hardship beyond what everyone is going through, which is being disabled and not being able to work substantially. It says, while most disability cases would be described as hardship situations, the decision to expedite processing may defeat the effectiveness of any priority plan for the processing of cases. Therefore, the facts of a given case, in consideration of the estimated time in which such a case may be expected to be processed, i.e. additional development required, consultation, etc., should be carefully weighed when determining whether a case should be given priority processing. So that's in a hardship situation. So an example of when this has come up. Okay, and this is actually an example of when not to try to say you have a dire need unless you actually do. Some of the things that it would involve might include if you are about to lose housing and you have no place to go. So that could be a mortgage foreclosure. And in my experience, they want to see that legal action has started. I don't see them detailing that here, but we can look elsewise to see if there's any of that in the POMs and stuff. But every time we have used that, the judge, and it's always been by the time it's getting to a hearing, because by then they've gone through initial and recon, and now they really haven't been able to pay their mortgage. So the judge, in my experience, has wanted to see that something has happened legally. Because, sometimes when we don't pay our mortgage, it can go years before they do anything. There was such a backlog at one time, I'm sure probably during COVID included. So just because you're behind your mortgage isn't necessarily going to get you there. And I should add that dire need cases that are, achieve the decision to expedite it, kind of prioritize it, they don't really go that fast. In other words, you're not going to get a hearing next week, generally. It's still going to be probably a few months. So, but here's an example also. If you're not paying your rent, you're going to be evicted and the eviction process has started. That is something where you're going to have a legal document showing that it's getting serious. But also, you want to be sure that you actually do have no place to go. Are you really going to go to a shelter? Or do you have mom and dad to go live with, or a brother or sister, a close friend? Be very careful about claiming that you have no place to go if you do. And I'll give you an example of where that can come bite you. I had a case, this is many years ago now, and she told me that she was getting evicted because she couldn't pay her rent, and she had no place to go. So she asked, can they speed it up? So I relayed that to the judge at the hearing, and I think the judge did make it a priority to get scheduled, which they do that. It's still going to be a couple months away, right? At the hearing, she asked where the client was living, and I, at the time, didn't realize this was going to happen. This is a long time ago, and the client had moved in with the boyfriend. So she got an expedited hearing when she wasn't living out in the street or going to be out on the street, or had been moved to a shelter, needed to get out of there fast because that can be an unpleasant place to live for very long. So she never updated anybody. And my bad, I didn't go and pester her about it either. I didn't actually realize at the time that it was going to be something the judge was going to bring up. It was a case of first impression for me. Like I said, it was a long time ago. I don't send letters to judges when clients ask me to. And if it's for something like that, and it has come up again, I make sure there is that documentation of some legal action, not just that things are unpleasant and I'm going to have to leave and I'm going to have to live with a boyfriend, or God forbid, I have to live with my parents, blah, blah. It's going to have to be more than that. And the judge was really definitely not very pleased with the fact that the client had requested dire need expedition because of having nowhere to go, and then she was living with a boyfriend. You can really, and I think she lost that case. We ended up refiling and then prevailing, but and the judge made it clear that any decision she made would not be affected by the living situation and the fact that it was expedited, and she didn't, as soon as she moved in with her boyfriend, change the request for the dire need expedition. So she said that, and I believe her. I mean, the case was very tough at that time to begin with. I mean, it was able to be improved upon evidence-wise when the claimant followed directions a bit better, but you really don't want to tick off your judge. So you're going to want to have some sort of legal action has been taken, or you're living in a shelter. I mean, if you are, you are. If you're living in your car, I suppose that might work too, but you're going to have to probably, if I were to do it for somebody now, I would have that legal documentation. If there was no legal documentation, but they are now literally out in their car or couch surfing, with various friends, places, I would probably have them do some sort of certified statement where they're certifying to me and the court that this is what's going on, because all you need is for it not to be true or to be interpreted as not true. And you just don't want to have that reflection on you. It kind of kind of hurts the credibility. So dire need oftentimes is losing housing with no place to go. They don't want to see people lose their mortgages either. Like if you're, it's one thing to get evicted when you're renting, because you're probably you're renting, you'll rent again. When you have a mortgage, that means you had or could have equity in a home. You might never have that again once you're on more limited income. But if you already have it, rather than having to then be a renter the rest of your life, you continue paying your mortgage if you get your disability. So if you are in danger of not being able to pay a mortgage, it's something to think about. Again, you might have to you can let the judge know that you're 4 months behind on your mortgage and say, is that sufficient? You know, you can always ask if is that sufficient for dire need, because I'm really afraid I'm going to lose my home before I win this case. But don't say I have no place to go if I have to leave, unless you know for sure that's the case. And they might and probably will still want to see it have progressed to some legal step where at least you've been given notice of an eviction or foreclosure, because pretty much not everyone, but such a large portion of people who own a home and then file for disability and don't have, say, a working spouse that can help meet those bills. And even sometimes when they do, because usually it's very hard to go from 2 income to 1, it is not unusual to fall behind on that mortgage. So they can't really accommodate everybody. Therefore, I think that is why it is generally, once some legal thing has come down the pike, some sort of filing has taken place. But before then, if you do get a letter from, I don't even know, like the rental situation, if you have a letter from the notice of intent from your landlord, that might be enough to just say, this is what I have so far. Can I get dire need? And they either will or will not give it to you. But you want to be very, very straight about it. And don't say you'll have no place to go unless you do. Okay. Dire need. There could probably be other ones, other reasons. But that financial reason is a biggie because it's very, very common. All right. I hope you're all having a good night, and I will talk to you next time.